Judge Henderson, may I open court?
All right.
Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 19-3040, United States of America versus Floyd Clark, Appellants. Mr. Kirsch for the Appellants, Mr. Randolph for the Appellate.
Mr. Kirsch, good morning.
Good morning.
If you'd like to proceed.
Yes, thank you very much. While the case was pending, the court asked specifically for argument regarding the issue of finality under 1291. So I'd like to start my initial 7 minutes of time addressing 1291. I would cite...
Excuse me, counsel, wasn't our question broader? What is the jurisdiction in this case?
Well, I read it as specifically whether or not the issue of finality was what the court wanted to address.
Yes, but that doesn't just refer to 1291, does it?
No, but in jurisdiction, are you referencing the 2255 issue that was raised?
Yes.
Yes.
But yeah, go ahead, and as far as I'm concerned, you can talk about whatever you...
Very well. Thank you, Judge. Well, under the 1291, I believe, is controlled by Gillespie versus United States, which is cited at 379 U.S. 148. It was a 1964 decision from the Supreme Court. And the Supreme Court said that under 1291, appeals must be taken from final orders. But then the court specifically said that a decision final within 1291 does not necessarily mean the last order possible to be made in the case. The court went on to say it is impossible to devise a formula to resolve all marginal cases. And in Gillespie, the court adopted or stated what they called the practical approach to the issue of finality. And that under the particular I would submit under the particular circumstances of this case, that for practical reasons, the issue that is before this court is in fact a final judgment, final order of Judge Friedman. The practical reasons we would submit are that the substantive issue, the recantation, was raised initially in a pro se pleading and then supplemented by counsel in 2015. The secondary issue on the 920...
Excuse me, counsel. The 924C issue is still before the judge.
That's correct. That's correct.
That's the problem. Isn't that the problem?
No, I would submit, Your Honor, respectfully, that under the practical approach, because the 924C issue arose subsequent to the substantive issue, that there is a good practical reason under Gillespie for the judge to have decided the substantive issue and for this appeal to have been taken at the time that he made the decision on the substantive issues. I would note that the government, well, number one, I would note that Judge Friedman granted the certificate of appealability. And in the motion for the certificate of appealability, in the government's opposition, they did not raise finality. So this came up just prior to this argument.
But counsel, jurisdictional issues doesn't have to be raised by the parties.
I understand, but I would submit to the court the fact that they didn't address it means that they weren't considering it. And that I think I would submit to the court that...
Counsel, that in 10 cents gets you on a trolley car.
Well, I would submit to the court. I understand what the court's saying, but I believe that using this practical approach and taking into account that Judge Friedman specifically issued the order, and in it, he also, well, he issued the order and then he issued the certificate of appealability, that he considered the issue to be a final determination. So I would submit under those factors, taking into account the nature of the case and also using the practical approach, I would submit that Mr. Clark has an immediate liberty interest in getting an adjudication on the merits of the substantive issues.
Mr. Kirsch, can I read a couple of quotes from a Second Circuit case, 1986. Obviously, it's not controlling on us, but it is as on point as I could find. It's called Bermudez v. Smith. And in that case, a habeas petition was raised at the district court on several claims. Some of the claims were decided, some of the claims were not. The habeas petitioner appealed to the Second Circuit, and the Second Circuit said, we don't have appellate jurisdiction here because part of the claims are still pending. And what it said is that a final decision generally is one that ends the litigation on the merits and leaves nothing for the court to do but execute the judgment. And specifically with regard to the habeas case with multiple claims, it pointed out that and I'm quoting here, to allow separate claims to be dismissed and then heard on appeal, while other claims remain to be adjudicated by the district court, which is exactly our case here, would encourage piecemeal and time-consuming litigation. It would run contrary to longstanding policy, grounded in the nature of the relationship between trial and appellate courts, including the saving of time and the avoidance of unnecessary expense and unnecessary appellate lawmaking, as well as a duplicative effort on the part of all concerned. As I said, that decision is not controlling on us, but can you tell me why we shouldn't find it persuasive?
Your Honor, I understand the reasoning in the Second Circuit, and that follows generally the reasoning of appellate courts that have addressed the issue on finality. My argument is that Gillespie opens the door a little bit and suggests that appellate courts should look at the practical approach and how does this affect, from a practical perspective, the litigant. I would note that this court, in a decision that was in an order, that was rendered in May of 2020, Earl versus Security and Exchange Commission. The site is Westlaw 4332907. In that case, that was an appeal from a denial of a partial motion to dismiss. And in Earl, this court said that the appellant did not satisfy under the practical approach. But what Earl versus SEC does say is that they reiterated the vitality of Gillespie and the notion in Gillespie that appellate courts should take this quote unquote practical approach so that litigants, when they have practical reasons why issues should be decided, you can still have remaining an issue before the trial court. So,
let me ask you, Mr. Kearse, I agree with you in this case in that if we were to rule with you, that would end this prosecution. The 924C, if we wait for that, is really the tail wagging the dog. And that is a practical reason to go ahead and consider this issue. But how do we determine if that's the test? In other words, what's left before the district judge, and if what's left is not determinative of whatever issue is being appealed, we would go ahead. Is that the test that you would apply, or that you think Gillespie would apply?
Well, I think, yes, Your Honor, I believe that, Gillespie leaves the door open and specifically suggests in the opinion that there's no, what they call a magic formula. Every case has to be decided on its individual merits. And in this case, the issues are completely separate. We have one recantation, and then the second issue, the subsequent issue is the 924C count. And we had to wait for a determination from the Supreme Court, which finally came down in the United States versus Davis on the 924C. That issue is now, the 924C is back before Judge Friedman, and there's a lot of litigation that is still has to occur in that case before a final decision on that issue can be adjudicated. So,
but if we were to buy your argument with this issue before us, the recantation, that's right, the end of the 924C.
That's correct, because that would be dispositive on the recantation. If this court ruled in appellant's favor on the recantation, Judge Friedman's already ruled that without Mr. Walker's testimony, the government has no case.
Right.
Are you relying on habeas corpus language or 1292? Which is it?
Well, the habeas is it's 2255, and we're dealing with the 1 year statute.
Yes, but your view is that 1292, with a more flexible view of finality, overrides the habeas corpus provisions?
Yes, and again, I would say that I understand what Judge Walker was reading from, and I understand that's the language you find in most of these cases. But we do have Gillespie, and I submit that the practical approach is, at least in this jurisdiction, still a viable approach to take in a case like this.
All right. If there are no more questions, then Mr. Kearse will give you a couple minutes in reply. Mr. Randolph.
Thank you.
Good morning, Your Honors, and may it please the court, Daniel Randolph for the United States. I'd like to begin also by addressing the jurisdictional issue that the court identified in its order. The government also believes that this was a final appealable order, although for a different reason and different rationale than was articulated by Appellant. As explained in our brief, Appellant's newly discovered evidence claim was in substance a Rule 33 motion. And because Rule 33 and Section 2255 are distinct procedural vehicles, this court has jurisdiction to review the denial of a Rule 33 motion, even though there are Section 2255 claims pending before a district court. And we would just point the court to two sources of authority for this proposition. The first is an older case from this court, but it's still good law and it's still cited in the treatises. That's Bruno versus United States, BRUNO. This is 180 F 2nd 393. And that's DC Circuit 1950. And this case holds two things that are important here. First, that a Rule 33 motion is properly understood as, quote, part of the original criminal proceeding. And the second holding is, quote, that a Section 2255 motion commences a new and independent proceeding. So not only are these different types of motions, but they're actually different proceedings. And then even more on point here is a Seventh Circuit case. This is United States versus Steele, Steele. And this is an unpublished case, but we would cite it for its persuasive value here. It's 72 Federal Appendix 478, Seventh Circuit, 2003. And this is a Fairchild-Posner-Wood decision. In a single motion, Appellant brought newly discovered evidence claims and constitutional error claims. And the district court denied the newly discovered evidence claims under Rule 33 and sent it up on appeal. The district court reserved on the 2255 claims, and the Seventh Circuit held that it had jurisdiction over the Rule 33 denial, even though there were still 2255 claims pending before the district court. And so we think that those two pieces of authority are fairly strong support for the government position here.
Counsel, what was the theory of the Seventh Circuit?
The theory, Your Honor, was that these are utterly distinct procedural vehicles, and that's a direct quote from the opinion. They have different time limits. They have a different scope in terms of the substantive claims that can be brought within each provision. And this is outlined in the government's brief as well, because we do think the procedural argument should carry the day here.
Did the Seventh Circuit conclude it was a final order?
Yes, Your Honor.
a final partial order, a partial final order. Is that correct?
Well, I don't recall that the court used the word partial.
No,
the court's holding.
That's in effect my understanding of the case, right? I'm not familiar with the case, but I gather you're saying it's the Seventh Circuit thought it was a partial final order, therefore it was a final order.
I think that's a fair way to characterize it. Yes, Your Honor. The holding was that.
I have great respect for the Seventh Circuit, but why isn't that gobbledygook?
Well, Your Honor, I think far from gobbledygook. I think it's actually the legally correct position here. This court has an obligation to look beyond the label of a motion and to construe it according to its substance. And that's especially the case when it comes to jurisdiction. And it's especially the case when it comes to habeas, because there are all sorts of incentives that litigants have to call their motions something other than what they really are. And, you know, one good example of this is, apologies, I'm going to cite another Seventh Circuit case here, but the Evans case that's cited in the government's brief, this is sort of the flip of this case. The defendant brought a Rule 33 motion, and the district court treated it as a Rule 33 motion. But this was Judge Easterbrook. He said, no, this wasn't a Rule 33 motion. This was a Section 2255 motion, and it's second or successive. And so the district court doesn't have jurisdiction over this. And so analogously, this court, we would submit, must do the same thing here with respect to appellants, what appellant has called a 2255 newly discovered evidence claim. This was in substance a Rule 33 motion, and that is also highly relevant for this court's jurisdictional analysis.
If we were to accept everything you just said, then that would save Mr. Clark here in terms of it would allow him to appeal the district court's order. However, it would doom his appeal because we would be viewing the original motion by him as a Rule 33, which we all agree is time barred. Am I following?
Yes, Your Honor. That's the government's position that this is the legally correct outcome here. Appellant's motion was in substance a Rule 33 motion, but it is time barred. Also, because it was in substance a Rule 33 motion, this court has jurisdiction to reach that holding. Unless the court has any further questions on the jurisdictional issue, just make a brief point about the procedural argument. We don't think there's a lot of gray area here. The law in this area is actually even more settled than the government initially understood when submitting its brief. In the course of preparing for this argument, came across another older case. This is from the World War II era, but it's from this court. And what happened in this case, this is Hodge versus Huff, Hodge versus Huff, Huff, 140 F second 686. And this is from 1944. And so it isn't cited so much anymore, but it's still good law. And what happened in that case, it was a habeas case, and the defendant brought a habeas motion based on perjury. And the court held that alleging perjury alone, without alleging and substantiating a claim that the prosecution either knew or should have known about that perjury, is not a due process claim, and it's not cognizable under habeas review. And so in some sense, we think this court has essentially answered this question 75 years ago. That's consistent with all of the cases the government did cite in its brief, including the Herrera case, as well as the Berry case, the Conley case from the First Circuit. So we think that this procedural argument really is the legally mandated outcome here, and that there isn't a whole lot of gray area.
Mr. Randolph, was Hodge an actual innocence case involving perjury?
Your Honor, it was not an actual innocence claim. And I'm actually not even sure that in the 1940s, the notion of an actual innocence claim was even in the lexicon. But on the actual innocence point, we would just point to the government's footnote 4 in its brief, which does explain that the Supreme Court has assumed without deciding that there is an actual innocence claim. But it has also assumed that if there is such a claim, the defendant would have to meet an extraordinarily high threshold to satisfy that claim.
I think the standard the Supreme Court says is the defendant would have to unquestionably establish innocence.
Yes, Your Honor. And so we would submit that appellant has not attempted to meet that standard here and could not meet that standard here. Seeing that my time has expired. Oh, sorry, I see that. Is there a question?
No. Not
Thank you, Your Honor. We would just ask that the court affirm the denial of appellant's motion. Thank you.
All right. Thank you, Mr. Randolph. Mr. Kirsch, why don't you take a couple minutes?
Okay, thank you, Your Honor. Well, let me just start out by saying there are some aspects that I believe both parties agree on, and that specifically that is that Rule 33 and habeas under 2255 are utterly distinct. We'll call them remedies, and there are different time frames, and so they are different procedures. One is part of the criminal case, one is actually a civil case. This case is litigated under 2255, which has the 1 year time requirement from when the defendant reasonably should have known about the evidence. Rule 33 is much more strict. It's much more firm. It's 3 years. You're either in or you're out, and there's no dispute. And I would direct the court's attention to Judge Friedman's opinion. He wrote a lengthy opinion in this case. It was almost 50 pages in length. And he tackled this issue head on. And Judge Friedman said that this is a 2255 because it raises a constitutional issue. It raises the Fifth Amendment due process issue. And as long as the 2255 raises a constitutional issue, the trial court has jurisdiction. And then this court, I would submit, would have jurisdiction to hear it. And that's how this case was brought. Judge Friedman specifically cited another opinion. I understand it's another trial court opinion, but he cited an opinion from Judge Hogan, where Judge Hogan ruled in a very similar situation that with respect to the issue of recantation, that this is a constitutional issue. So we submit that this court should decide the issue under the 2255, which is what Judge Friedman did when he had the opportunity to rule upon it. And I see that my time is just about up, and so I will conclude with that.
All right. Thank you, gentlemen. If there are no questions, then the case is submitted.
Thank you very much.
Case number 19-1234. Philip Lawrence Sundel, petitioner, versus United States of America. Mr. Sundel for the petitioner, Mr. Smith for the respondent.
Mr. Sundel, good morning.
Good morning, Judge.
If you'll proceed.
Thank you. May it please the court. The judge below denied a U.S. citizen the right to attend a U.S. criminal proceeding in the United States.
Can I stop you right there? Can I stop you right there, Mr. Sundel? I don't think it's a criminal proceeding. It's a military tribunal of an enemy combatant while the war is still going on. And I guess like my question is, let's assume that we get past the procedural stuff and we have to decide whether there's a qualified First Amendment right here. So we're kind of not as far to the end of the analysis as deciding how we would apply a qualified First Amendment right, narrow tailoring, et cetera. But we are past the procedural stuff. Is there a qualified First Amendment right for a member of the public to watch a military tribunal of an enemy combatant while the war is still going on? And the answer to that has to be an inquiry into history and experience. And in the Revolutionary War, we had such tribunals, and my understanding is they weren't open to the public. Andrew Jackson had such tribunals. My understanding is they weren't open to the public. In World War II, we had such tribunals, and my understanding is they weren't open to the public. So I guess my question to you is, during that time frame, it's 170 years or so, the first 170 years of the country, do you know of any examples that you can give us where a military tribunal of an enemy combatant, foreign enemy combatant, during the war, where a court held that a member of the public has a First Amendment right to watch that, even if it's unclassified, a First Amendment right to watch that?
Your Honor, I would submit two things on that issue. The first is that the closest analogy is other military tribunal proceedings, such as courts-martial. And courts-martial, in fact, have no history of being closed proceedings.
Why is why can you tell me why that's the best analogy and not other military tribunals of enemy combatants while the war is still going on?
Well, as far as other military commissions, I believe that Civil War military commissions were open. I don't know of any indication that they were closed. Now, granted, this court and the Supreme Court have acknowledged that there are differences, subject matter differences to some degree with Civil War commissions.
Well, can I interrupt for a second so that I can ask some questions about what you just said? The Civil War commissions would not have been foreign enemy combatants. They would have been American citizens. That seems like a difference. But in addition, if you're talking about the Booth conspirators and the Andersonville war crimes trials, those happened after the war had ended. I know there were some during the war, but can you talk to me about them, and also why the distinction between Alcosi being a foreigner and the Civil War concerning American citizens, why that distinction shouldn't matter?
Well, the First Amendment right, the public's First Amendment right to attend is sensitive to circumstances like that, but there's nothing about the nature of the defendant that any court that I'm aware of has ever pointed to say that there is not a First Amendment right to attend. It's the nature of the proceeding. It's the need and the right of the citizenry to monitor government activities, particularly with respect to proceedings like this that are judge alone. Military commissions, whatever they may be, can result in a death sentence. So whether or not they're technically criminal proceedings, military proceedings have always been reviewed as criminal proceedings. The due process review standard is that of a criminal proceeding. This court has acknowledged that the military commissions here, because most of them are death eligible proceedings, are subject to the appropriate standard of review for a death eligible proceeding.
Mr. Sundel, I'm not sure that I agree with you that the same due process rights, the exact same due process rights that apply to federal criminal trial also apply in a military tribunal of an enemy combatant of a foreign enemy combatant while the war is still going on. But even if they do, we're not talking about the defendant's due process right. We're talking about the public's First Amendment right to watch. And I can't think of.
May I come in at that point?
Yes, please. Yes, please.
I happen to agree with the line of questioning my new colleague has presented, but I have a precursor question. Why do you have prudential standing to sue as a member of the public?
Petitioner is a member of the public. Petitioner has never had.
That's you, right?
Yeah, it's me. I just feel odd referring to myself in the first person.
Well, because if you were counsel to some a defendant before the commission, you would have an entirely different position. But I'm trying to understand. You are challenging the government's policy. The government's policy is that they do not want to open these proceedings, right?
Yes, sure.
And they don't want to make an exception because any individual has a clearance. So you're challenging the government's policy, right?
No, the government has never.
Wait a minute. You're challenging the government's policy, and you're purporting to be a member of the public, but you're not a member of the public. You're indeed a government lawyer. If you were right that any government lawyer could step out of his or her government position and sue the government as a member of the public in a situation like this, then any lawyer in the National Security Division could be in court challenging the National Security Division's position on this case, right?
Your Honor, I have no official role in this case whatsoever. So I have not waived my status.
I'm not suggesting to you, but if you were right, any lawyer in the Justice Department could appear in this court asserting the right as a member of the public, challenging the Justice Department, right?
Yes, I do not believe that accepting government employment renders me not a member of the public for all purposes.
For certain purposes, you're certainly a member of the public. There's no question. If you made a speech on a certain subject, then there would be a question of First Amendment protection and a sort of practical accommodations made. But you're not doing that. You're suing, as a member of the public, the government.
For my First Amendment right to attend.
But if that's true, any lawyer in the Justice Department or all the lawyers in the Justice Department could come in challenging the position of the National Security Division, right? On the grounds that they're members of the public.
I think that is correct. In their individual capacity under their First Amendment right as members of the public, yes, I think that is right. They could. I do not believe that the status of government employment renders the First Amendment inapplicable to someone.
Counsel, you're overstating. I didn't say the First Amendment is inapplicable. The question is, in this context, can you rely on the public's First Amendment rights? Why are you bringing this case? What's the reason? Is there
I'm sorry?
Is there a backstory here?
There is not a backstory. I had an interest in attending the proceedings, and I sought to attend, and I was told that I was not allowed to attend. And I believe that that's a violation of my constitutional right to attend public proceedings. The government has always treated military commissions in general and these proceedings specifically as public. There were media advisories. There's a transmission of the hearings to remote viewing locations in the United States. So I don't believe that the Supreme Court looks to the nature of the proceeding to determine if there is a public right to attend. It does not look to the type of evidence that is being presented, except with respect to whether there is a compelling interest. So yes, I believe that a government employee who does not have an official role in a proceeding retains his or her First Amendment right to attend public proceedings. And I believe
it's not just attend, it's also to challenge the government's position on this.
Well, I realize my time is up if I can continue answering. One goes hand in hand with the other. If there is a right to attend, then the case law is crystal clear that there must be a mechanism to challenge a closure order. If there is no right to attend, for example, if it's not a public proceeding, or if you are not a member of the public. And with respect to member of the public, if I could just briefly say, the military commission rules of procedure, just like the rules of courts martial procedure, define member of the public quite broadly. And in fact, the courts martial rules of procedure, which the court below, CMCR in a different case, has acknowledged are essentially identical to the military commission rules, basically say even government employees, specifically say even government employees are members of the public. So as far as the procedures relevant to these proceedings are concerned, the government, the procedures themselves recognize a government employee still having the First Amendment right to attend public proceedings, which is all I am seeking to vindicate here.
But now, Mr. Sundel, I thought that you're just not an unqualified member of the public. I thought your security clearance is, you're arguing anyway, gives you special status as a member of the public to have access to the closed portions of this hearing, which even the public is not entitled to.
Not exactly, Your Honor. The argument is that the petition, the respondent had the burden of demonstrating a substantial probability of harm to its compelling interest. And with respect to the judge's determination of substantial probability of harm, a relevant consideration for the judge is that respondent has itself said on numerous occasions over the last 10 years that petitioner does not represent a risk to national security. And in fact, petitioner's access to national security information is entirely consistent with the national security interest. It's not that the clearance gives anyone a special status. It's the fact that the government has repeatedly made the risk determination in favor of respondent that was a relevant consideration with respect to determining if the respondent had carried its burden of showing substantial probability of harm. The respondent theoretically could have pointed to a whole bunch of things to demonstrate substantial probability of harm. It pointed exclusively to need to know, which is irrelevant because it's a generic, unspecified risk. In response to the respondents seeking to close, petitioner said, I am not a risk. And one of the things that you should consider in determining if I am a risk is respondent's own view that I am not a risk.
All right. We'll give you a couple minutes in reply.
Thank you,
Mr. Smith.
Thank you, Your Honor, and may it please the court. Jeffrey Smith for the United States. As the panel's questions suggest, there's an incongruity here between what Mr. Sundel claims, which is a First Amendment right to attend, and the fact that he only has this right in his view because of a security clearance he has as a government employee. Under this court's precedent in Diab, a classified hearing can be closed to the public. And once a hearing is closed to the public, there is no First Amendment right of attendance. Mr. Sundel is advancing the argument that the government has to demonstrate, over a strict scrutiny standard that each individual person who wishes to attend is a security risk. And that has never been the standard. It's not a workable standard, and it's a standard that's entirely inconsistent with national security. Under that legal rule, anyone that the government, perhaps mistakenly, not in this case, but perhaps in another case, the government mistakenly cleared someone like Edward Snowden, that person could go around to every court and get every classified transcript, get every classified filing, and do whatever he wanted with it. And that is a huge risk. That is why the government has a need to know compartmentalization within the executive branch.
Counsel?
Yes.
What about my concern, for one thing, as to why the appellant in this case has prudential standing. If he does have prudential standing, then any of your colleagues in the National Security Division could bring the same case against you and against the policy of the government.
Yes, I think that's right. I mean, I think anyone who who claimed that they wanted to attend a hearing would be able to do that under the theory that he's advancing.
Yes, but
and then that would include anyone in the national security.
I got the hint in your brief that this was incongruous, which the other way of phrasing that is prudential standing. Do you believe he lacks prudential standing to sue as a member of the public? Because he was after.
You're on.
Go ahead.
I'm sorry. I mean, in light of Lexmark and this court's case law interpreting Lexmark, it's not clear whether prudential standing is the right analysis. I think it may be that it's a merits question that the court should only reach, assuming that it finds jurisdiction, and there is no jurisdiction here for other reasons. I'm not sure if that's a satisfactory answer, but I'm not sure that I can answer it beyond that. But I agree that the underlying concern you raise is a valid one. I just think it may be a merits question.
Why is that? Well, why wouldn't you? Would you? Why is it a merits question? I don't. If you would you understand his position that any lawyer in your division could take the same position as he's taking, attacking your representation and the policy of the government? You understand that? That's his implication of his position.
Yes, that's.
You don't think that raises a standing question?
Well, again, this is a somewhat different answer. To the extent that the question is whether the injury is concrete and particularized as to him, or whether it's so generalized, which may be what you're getting at. That would be...
That's a Article 1 question, Article 3 question.
I agree.
We're talking about prudential standing. I'm not asking whether he has injury in fact. Of course he has injury in fact, because you have to assume the merits on that. But prudential standing asks the question, is this individual entitled to make this claim? And you have to consider, if that's true, then any lawyer in the Justice Department could have raised the same claim challenging the Justice Department's position. You understand that?
Yes, I do.
And you think he has standing? Such a lawyer would have standing to do that?
I think it's. I mean, I think it's probably a merits question, Your Honor.
I don't see what. Okay, I don't see that as a merits question at all. Why do you say it's a merits question?
I mean, that's how I read Lexmark, and this court's case in Crossroads grassroots policy, which refers to the zone of interest tests, but
no, but that's under APA. This is a constitutional prudential standing question. That's entirely different. They rarely come up, but you can't look to the APA on that because, as I once said, that's statutory standing, and I was gratified that I was quoted by the Supreme Court on that. That APA is entirely different. There are few cases on constitutional standing, but it seems to me this falls within that category. The question is whether a lawyer in the Justice Department or Defense Department can challenge government policy with respect to closing the hearing, notwithstanding the government is taking an opposite position.
Okay, I think I understand.
What happened?
He froze. I hope Ann can take care of that.
I don't, again, it's debatable whether it is, of course, I'm sorry, my connection is, sorry, Your Honor?
We can hear you now.
Oh, okay. But I would just like to point out that there are two other jurisdictional problems with this case. One is that this doesn't fall within the statutory jurisdiction that Congress has granted. The statute that governs this court's appellate review over the military commission system is 10 USC 950G, and that statute grants this court with jurisdiction only over final judgments issued by a military commission and approved by the convening authority, and further restricts the court's review to the findings and sentence of the military commission. It's clear from both the text and the context that this is a reference to military commission convictions. That's what the court is granted jurisdiction over by Congress. And the
Counsel,
order at issue here.
Counsel, you would agree that mandamus could lie?
It may be the case that mandamus would lie. I don't think the court needs to reach that because Mr. Sundel has not sought mandamus, and mandamus would not be appropriate, but it may be.
I agree with you. For instance, if the commission rejected a participant on the grounds he was Catholic, there was certainly mandamus would lie, wouldn't there? Wouldn't it?
I'm sorry. Yes, I believe it would.
Yes, but your answer is he didn't seek mandamus.
Well, that's my answer is he didn't seek mandamus. Mandamus would not be appropriate because he doesn't have a clear and indisputable right to relief here. And it's possible that there are, and this was something that we'd need more briefing on, but there may be alternative remedies as well to the extent that he seeks a transcript from the Department of Defense. So in any case, I see my time is almost up. This court doesn't have jurisdiction under 950G, doesn't have appellate jurisdiction. And this case is also not right for reasons that we put in our brief. So if the court doesn't have any questions on that, I would stand on our arguments in our brief and ask that the court dismiss the petition.
All right. If there are no more questions, then Mr. Sundel, why don't you take 2 minutes and reply?
Thank you, Your Honor. Briefly, with respect to jurisdiction, the jurisdictional provision is 950GA, which is a standard finality provision. As this court has said with respect to the Hobbs Act, finality provisions that are analogous to 1291 are appropriately viewed through the collateral order doctrine, and challenging a closure order for unconstitutional grounds is a classic collateral order review case in this circuit.
Mr. Sundel, the 1291 talks about final decisions. 950G talks about final judgments. Judges make decisions all the time that are not judgments, and Congress made a choice to not use the word decision, but to use the much narrower word judgment in 950G. So I'm assume that I don't think we should read judgment to mean decision. Is there a way for you to still win, to still have jurisdiction here? Why should we think of what happened to you as a judgment?
Because the phrase judgment in 950GA is simply intended to recognize the unique way in which military cases conclude are final. So military cases writ large are only final after the convening authority approves the findings and sentence.
That explains why Congress would have added the phrase after the convening authority approves it, but it doesn't explain why Congress chose to use the word judgment instead of the word decision. And you're asking us to divine congressional intent, but I'm asking you why. Usually the text is our guide to intent. Why is the text not the guide to intent here?
We agree that the text is the guide, and the text clearly demonstrates Congress's desire for military commission review to be funneled into this court. There's really no question that Congress did not want district courts and other circuits reviewing the judgment of military commissions, and that is what would happen if review is not under 950G. In fact, the first hearing in this case was in Maryland, so we would be bringing in yet another district and circuit to review a military commission judge's order when the structure of...
Excuse me, counsel. You don't have any decision by the convening authority in this case. Even if we were to read judgment as you would like us to read as decision, you don't have any reaction from the convening authority, do you?
The final judgment, if read via the collateral order doctrine, would include exactly this claim, because this claim is a classic collateral order. So unless...
Well, even assuming that you could double stretch judgment to make a decision and get a collateral order, doesn't the statute require the convening authority to approve the position?
That's merely a recitation of the statutory scheme for military decisions. So adding as approved by the convening authority is simply an acknowledgement of when those decisions are in fact final in the context of military judgment. It avoids the confusion of when the judge closes the case in a military commission or a court-martial. Normally you're looking at a criminal proceeding, that would be the end. But all that language recognizes is, like administrative board decisions that are not final until the secretary approves them, such is the case with military court-martial and commission judgment. They're not in fact final until they go through the convening authority. So the statute that language doesn't add anything to the process. It doesn't add a separate requirement. It simply highlights that is in fact what the statute means by final. Otherwise, there could be confusion for anyone who's not familiar with the military process for finality. So, and if I could just very, very briefly touch on a couple of things. Federal defenders frequently file in opposition to the government. That's a necessity of their independent role.
Oh,
my
sure.
office.
Sure, you're like a public defender, right? Paid by the government. Certainly, if you were representing a person, who claimed a right, that would be a different. Your posture would be entirely different.
But as a public defender, I do not lose my individual First Amendment right to attend a public proceeding.
Are you asserting any superior right because you're a public defender?
No, absolutely not. I'm just distinguishing your hypothetical with an NSD employee.
Oh, wait a minute. In other words, you are in a different position than a lawyer in the National Security Division who disagrees with the policy.
Well, I certainly think that there is a much greater opportunity for the government to restrict the personal activities of a lawyer whose job it is to represent the government, as opposed to a lawyer whose job it is to oppose the government. So if there's a need to distinguish with other government lawyers who should not be allowed to pursue this sort of a claim, that is certainly a recognized distinction. I only technically work for the government. My job, in fact, is to oppose the government. And if there is any need for that distinction to carry over into a First Amendment right, it certainly should. Diab was a civil case, and it itself recognized that national security concerns, national security equities, and the need to close proceedings or to exclude evidence in a criminal case is very, very different, and the government is not entitled to the same level of deference. This court has also recognized...
But let me come back to your point, counsel. You're not arguing that you never in your brief suggested you had a particular right that no other government employee would have, because your general job was to defend persons charged under the military commission.
No,
So
now
you're saying you really don't have a public right. You have some kind of governmental function right. That's different from the claim.
No, Your Honor. If that's what it sounded like, I'm sorry that I misspoke. All I'm saying is that if some aspects of government employment infringe on the First Amendment right to attend as a member of the public, then there would be a distinction with government employees whose job it is to oppose the government as opposed to represent the government. I'm not conceding that there is an appropriate limitation on that right, but if there is, then it should be distinguished based on the role within the government. I realize I've gone way past my time. I thank the court, and if there are no other questions.
Any more questions?
No.
All right. Thank you, gentlemen. Go ahead, Judge Silberman. Did you have a question?
No, I did not.
Oh, all right. Okay. Gentlemen, the case is submitted.
Case number 19-5284, the American Council of the Blind and Patrick Sheehan, Appellants, Otis Stevens versus Stephen T. Mnuchin, Secretary of the Treasury. Mr. Levitke for the Appellants, Mr. Winnick for the Appellate.
Mr. Levitke, good morning.
Good morning, Your Honor, and thank you, and may it please the court. I'd like to begin by noting that there is not a single declaration in the record of this case that states that it is impossible to add a raised tactile feature to all denominations of bills by 2026. There is not a single declaration from any official, the BEP, the Department of Justice, the Federal Reserve Board, Treasury, or anyone else that makes that statement.
Wait a minute, counsel. I'm not sure I understand. I thought, reading the briefs, that the government had indicated that they don't know how to do it at this stage. They simply do not know how to do it.
That's true, Your Honor. They said that, but that doesn't mean, Your Honor, that it's impossible. The district court found that it was impossible.
Well, does it matter whether it's impossible or they simply don't know how to do it? How can we order the government to do something they don't know how to do?
Well, Your Honor, first of all, to back up, this case has a very long history. It was the government's decision, not ours, to choose the raised tactile feature as their preferred method of accessibility. There are other more commonly used methods, such as changing the size of currency, etc. They could have done that, but they just said, no, we don't want to do that because it's too expensive. And now, 10 years after they decided that they were going to use the raised tactile feature, all of a sudden they come up and say, we don't know how to do it. But yet, if they don't know how to do it, Your Honor, I would submit to the court, why are they saying in the status report filed with this court just yesterday that they expect to do it by 2026? Certainly there is some inconsistency there.
Well, they're hoping they can figure out how to do it.
Well, Your Honor, they didn't say they were hoping to. They said they expect to.
Well, but the problem is they don't know how to do it now. And apparently other countries around the world are struggling with that effort unsuccessfully.
Well, Your Honor, there's a mixed bag of opinion on that. Frankly, there are many people, including Cummins Allison, who said that they manufacture the ATM machines in Canada that are used in Canada. It's in the record. And they say it was successful. They're able to use this equipment on ATM machines, on existing banknote machinery without a problem and without any undue expense. They're able to use the raised tactile feature. I don't see, if they're able to use it in Canada, why they can't use it here. But more importantly than that, Your Honor, the government's position is that they expect to do it. This is their statement. They expect to do it in 2026. And frankly, if they say they can't do it, then they're the ones who should be moving for a modification of the injunctive order, not me. The fact is, Your Honor, it's one thing to say you can't do it right now. It's not the same thing to say you can't do it in 2026. Those are two different things entirely.
Mr. Levicki, let me follow up on what you just said, because it's not clear to me that you're wrong when you say maybe the government should be filing a motion to modify the injunction. This is, as you pointed out, a case with a long history. And one of the original court findings was that the blind lack meaningful access to paper currency. And our court, the DC Circuit, has agreed with that part. The DC Circuit has also said that an accommodation is required if the accommodation does not impose an undue burden. That's what the Rehabilitation Act requires. An accommodation if it does not impose an undue burden. Our court has further said that increasing the size of the numbers on the bills and making the colors jump out more is not an undue burden. So far, so good. But we've also said that that alone does not provide meaningful access to the currency. And I think that the government, you, the district court, and the two panel decisions from the DC Circuit are all in agreement on those four things. Now, here's where I think it gets a little trickier. The circuit court has never held, I don't think, and you please correct me if I'm wrong, this court has never held that there is an accommodation that does not impose an undue burden and that does provide meaningful access. And assuming that this court has not held that there is an accommodation that does not impose an undue burden and that does provide meaningful access, I'm not convinced that there is such an accommodation. And if there isn't, then the injunction ought to get modified to say that the government does not have an obligation to provide meaningful access to paper currency because there is no accommodation that can accomplish that without an undue burden.
Well, Your Honor, in theory, what you say is true. The problem is it just doesn't comport with the facts of this particular case. The government hasn't even approached in making an undue burden argument. An undue burden argument would be based on cost estimates. It would be based on financial issues. There's no cost estimates in the record. It's pure guesswork to say it would be undue burdensome at this point.
Well, undue burdensome does not necessarily relate to cost. I know you've argued that it's only cost factors that prevent the Treasury Department from hiring enough people to solve the problem. But it's not just a cost factor. There are limits, technological limits. There are not that many people who can provide this work.
Well, Your Honor, if you are correct,
that's a cost factor by itself.
If you are correct, Your Honor, then why doesn't the government say that in a declaration? Why don't they just say, we can't do it? Why don't they just say, this is technically not feasible?
No,
why
they didn't quite say it. They said they don't know how to do it now.
Okay, Your Honor, but that's not the same thing as to say, and I just don't want to, beg the question with you, but I just don't see how saying it's not possible, that it can't do it right at this particular second means that it's impossible, especially in light of their continuing assertions just yesterday before this court, on Wednesday before this court, when they say to you that they expect to add an RTF to the bill by 2026. It just doesn't make sense, Your Honor. The record just doesn't add up. It just doesn't get there. Now, the government could have asked in this case, they could have said, look, we want to keep the record open a little bit longer to see what we can do and what we can't do. They could have said that, but no. The government said, we want the decision on the existing record right now. The counsel asked the court to keep it open longer. But no, they wanted a decision right now on whether or not it's impossible. And they got a decision. The district court judge obliged them.
Mr. Levitke,
no evidentiary record. There's not a single declaration in the record from one government official that says they can't do it.
Mr. Levitke, I've been thinking about changed circumstances. The suit was brought 18 years ago. If I remember right, the district court's original declaratory judgment was 2008. I might be off by a couple years. But technology with regard to how we use money, how all people use money, those with a disability and those who don't have a disability, has changed. I tried to think this morning how many times in the last month I've used cash. And I came up with...
I'm hysterical because I went through the same process. I was about to ask.
And I won't speak for Judge Silberman and how many times he's used cash in the last month, but I've used it once in the past 31 days. I've used it once. Now I know that not everyone is in that situation. Not everyone can get a bank account. Not everyone can get a debit card. But bank accounts and debit cards do not have the same costs and credit requirements that credit cards do. I think your position, and I'm not saying I disagree with it, I think your position is that the Rehabilitation Act requires that so long as people who are able to see have access to paper currency, there's a federal right of access to paper currency of people who have vision problems. And I guess if you could elaborate on that a little bit, I'd be grateful. Again, I'm not saying I disagree with you, but I am just kind of wondering, 18 years into this, tell me why debit cards don't solve the problem.
Well, let me interrupt and say, I use cash every single day. I have a bank account. I have a credit card. I have a debit card. Go ahead.
I'm not going to ask you what you're using cash for.
Your Honor,
go ahead, Mr.
First of all, Your Honor, I'd like you to know that at this very moment, your tax dollars are being used to build a brand new currency facility in Maryland. And the reason they're building that brand new currency facility in Maryland is that the government expects that the use of cash is going to increase over the next 10 years. And that's in the record of this case. So as my position is, if the government wants to move away from cash, then fine, that's fine. But they're not doing that. They intend to increase the supply of cash. That's why they're building a brand new facility at the cost of tens or hundreds of millions of dollars. I don't know what, in Maryland, and an improvement to the one in Fort Worth, because they anticipate an increase in cash usage. So this is all in terms of...
Yeah, but the real question that seems to me that Judge Walker is raising, but it may not be legitimate for us to open this up because the government hasn't argued it. But the real question is, for the hearing impaired, isn't there an easy alternative using credit cards or debit cards?
Well, Your Honor,
I agree with you. We can't really rely on that because the government hasn't said it.
Right.
But it's a practical matter, isn't that true? If I were blind, I would use a credit card or a debit card all the time.
Well, first of all, Your Honor, you get a few practical problems these figures are in the record of the case. But I think, believe it or not, this is surprising, but it's from the Federal Reserve Board. I believe almost 60% of the people in this country, especially poor people, do not have credit cards or debit cards. We think we all do, of course, but there are a lot of very poor people, especially poor people who are older and who are living just at the poverty line, frankly, that just don't have them. They can't get them. So I would think that, but before we go down that road, Your Honor, you'd want more information on the record here in terms of.
I agree with you. The government hasn't argued this. So it wouldn't be legitimate for us to consider it. But I couldn't help but agree with Judge Walker. It seemed to me this was a device. Suppose the government gave blind people or hearing impaired people a concessionary credit card or debit card.
Well, that's possible, Your Honor. I just don't know. It's just, I could only argue what we've got in front of.
No, I agree.
And the government has given these audible readers to the vision impaired, and they have very serious drawbacks. Our own colleague uses one and says that, and I'm sure this is the case with others, that when it's audible to people around that he's got a $100 bill or whatever, that's a huge security risk. And added to that is the fact that the vision impaired don't know who is around when this audible reader says whatever it says about you are handing a $100 bill or that is a $100 bill.
That's an interesting point.
All right. Mr. Leviticky, we'll give you a couple minutes to reply. Mr. Winnick.
Good morning, Your Honor, and may it please the court. Daniel Winnick for the government. Redesigning the currency is a monumental task, and in recognition of that fact, Judge Robertson decided in 2008 not to require the Treasury Department to undertake two separate redesigns of each note, one for accessibility and another for security. Instead, he directed the department to make each note accessible when it was next redesigned for security reasons.
Counsel, let me go to the question I asked your colleague. Do you know how to do it now? Do you know how that you raise the numbers now?
So I appreciate the question, Your Honor, because I appreciate the opportunity to clarify. What we've said is that we haven't yet completed the testing, the extensive testing required to assure ourselves that a feature will satisfy all of the criteria. But we have done over the years a great deal of testing and have arrived at the point of recommending to the relevant committees any day now. And we expect that the secretary will determine by the end of the year a particular application method for a tactile feature. And we have every expectation that feature, as applied in that way, will be applied to the $10 note by 2026. So we're not throwing up our hands by any stretch of the imagination, and we're certainly not speaking out of both sides of our mouths on this. What we've said is that because this is such a difficult project, we need to finish the testing. We need to do everything required to assure ourselves, but we do have an idea that it's going to work.
You have an idea that it's going to work, but you don't know at this point.
We have not completed the final testing required to assure ourselves that the feature is sufficiently efficacious, that it works with all of the other security features on the redesigned note, et cetera. But we have every expectation that this is going to work, that these tests are to confirm that, and that we'll be able to implement it on the $10 note in 2026. We are by no means at the point of throwing up our hands and saying we don't think we can do this.
Then why do you object to a deadline?
Simply because, a couple of points, Your Honor. First, the deadline, the motion that they actually brought was to require the $10 note to be rendered accessible by the end of this year, which I think everybody agrees at this point is not possible, and to have every denomination rendered accessible by 2026. And the fundamental problem with that proposal and the primary basis of the district court's ruling is that doing that would require the department to decouple the security and accessibility redesigns. It would require the department to focus first on issuing a redesigned note in each nomination that is accessible, that has a tactile feature, and only then to do the security redesign of each note. And the effect of doing that, the record is quite clear. The effect of decoupling the redesigns and prioritizing the accessibility redesign would be to delay the security redesigns. And so the primary basis of the district court's ruling was that the district court didn't think it was equitable to impose on everyone in the country, every individual, every business, and law enforcement, the burden of the increased risk of counterfeiting in whatever marginal period of delay there is, in order a delay of the security redesigns, so as to decouple the redesigns and do accessibility first.
Well, wait a minute. I gather you expected if you coupled the two, you could do it by 26.
We could do it by 2026 for the $10 note. Every note is distinct. They all have distinct versions of security features. And so that's why there is a staggered rollout schedule.
So you're suggesting you have no objection to an order, modification of the injunction ordering you to provide the $10 note by 2026?
Our objection to that, Your Honor, is based simply on the fact that, as the history of this litigation has showed, there are lots of contingencies here, and everything is dependent on testing. And the Secretary's statutory obligation is to ensure that the notes are best protected against counterfeiting, which was the cause of the delay from 2020 to 2026. So our objection is we wouldn't want to be in the position of contempt if further developments cause a delay in that date. I don't expect that. Certainly, we continue to expect the note will be ready in 2026, but that's the only objection to putting that in a judicial order, is that it becomes enforceable by contempt if there are further developments. I would note, of course, that plaintiffs haven't asked for that. That's not the modification they proposed, and the case law is quite clear that the district court's job under Rule 60b-5 is to assess whether the proposed modification is suitably tailored to change circumstances, and not to consider whether any modification of the injunction might be equitable. If plaintiffs wanted to move for relief limited to that, which is some version of what they did back in 2012, they're of course free to do so, and then there would be briefing and a decision and potentially another appeal from that. I did want to make sure I speak a little bit to plaintiffs' accusations of bad faith. I mean, the district court recognized repeatedly, with great familiarity with this record, that the Department of the Treasury and its staff have been working in good faith to comply with the current injunction. I certainly don't deny that the process of developing a tactile feature has been frustrating for everybody involved and has taken much longer than anybody expected, but there's no basis for plaintiffs' assertions of deliberate delay or deception. And again, as I noted earlier, the latest status report that we filed indicates that we are on the precipice of recommending an application method to the relevant committees. We expect the Secretary will approve it by the end of the year, and we have every expectation, although subject to confirmatory testing, that it will be ready to implement on the $10 note by 2026. On feasibility, what I would say principally is that that's not the primary basis of the district court's ruling. The district court didn't say principally I'm not ordering the department to do this because they just can't do it. The court did say that, it did offer that as an additional reason why the modification shouldn't be granted, in addition to the delay to the security redesigns that it would cause. But really, the basis of the district court's ruling was that decoupling the security and accessibility redesigns would delay the security redesigns and thus expose all Americans, individuals, businesses, and law enforcement to the risks of increased counterfeiting in the period of delay.
Mr. Winnick, you may not know the answer to this. It's okay if you don't. But do you know if any time and any money has been spent by the Treasury on deciding what person to put on the $10 or $20 bill?
So, Your Honor, as you know, I think public reporting has reflected there has been, you know, I think some time spent in addressing that, and a decision was made at one point. And I honestly don't know the current status to replace one of the portraits. I want to emphasize there is no such thing as a portrait redesign independent from a security redesign. What happens is that when the currency is regularly redesigned for security reasons, other changes can be made to the.
I understand, but part of what the American Council for the Blind is, I think, understandably frustrated with is that this suit was filed 18 years ago. They still don't have access to paper currency. The Rehabilitation Act has been interpreted to statutorily require that the Treasury Department provide them with access to paper currency. Of course, statutes also require the Treasury Department to make this currency secure from counterfeiting, and that takes time and money. Both of those things take time and money. But to my knowledge, there's not a statute that says Treasury must, as a matter of federal law, change the picture of who's on the $10 or who's on the $20 bill. So I guess my question is, why has Treasury spent time and money on who should be on the bill instead of spending that time and that money on the security features and the accessibility for the disabled community features that Treasury is statutorily required to do?
I think I can safely say, Your Honor, that any time and money that has been spent on the contemplation of portraits has not delayed this timeline, and we've certainly never offered that as a reason to justify the timeline that has occurred. I agree completely with Your Honor's basic premise, which is that this has taken a long time and that some frustration is understandable. I'm not here to say that this has been a process anybody has been delighted with, but it has largely been a result of the fact, first, that developing a tactile feature has been incredibly challenging, as it has.
No, I get that, Mr. Winnick, from the briefing, and I don't doubt that it's a challenge to the tactile feature. As I said in the beginning, I'm not sure, frankly, that you're ever going to be able to do that. But you would agree with the logic, at least, that if an agency spends time and money on one thing, that means it has less time and money to spend on another thing.
At a general level, I accept that logic. I think the record doesn't remotely reflect, and I frankly don't know that there has been sort of appreciable amounts of time and money spent on the portrait redesign, and I haven't heard any suggestion that has caused the setback in the schedule. The delay from 2020 to 2026 happened in 2016 when the department became aware of significant new counterfeiting challenges that in the Secretary's judgment required an additional 6-year period of the security redesign in order to ensure that the redesign note would be able to address those counterfeiting risks on a forward-looking basis. It didn't occur in any way because of contemplation of portrait changes.
Of course, we could modify the order by giving you direction as to who to put on the $20 bill. I have a clear idea who that should be, but maybe that would help the process along.
I thank Your Honor for the suggestion. In all seriousness, again, we recognize that this process has been imperfect. The department is committed to making this work in the best way that we're able. We are undertaking testing even now, as the status report reflects, to ensure that the tactile feature that's recommended for application will be able to satisfy all the criteria and work with a secure and effective currency, and we have every expectation of being able to implement that on the $10 note by 2026 and on subsequent denominations on the schedule we've laid out. And if there are no further questions from the court, we'd ask that the district court's denial of the motion be affirmed.
Right, thank you. Mr. Levitsky, why don't you take a couple minutes?
Thank you, Your Honor. Well, first of all, just to note that we agree with court that I believe it was Judge Walker who said that if they're going to change the portrait on the note, that then they should make an accommodation change for the blind and visually disabled. And we've raised that point with government. Now, with respect to the issue of the delay of the security redesign, if you look at the rationale for the delay of the security redesign, it's largely fictitious. They say that the delay will be due to the fact that they'll be required to add resources for the purpose of including the RTF on the legacy 2020 note by 2020. But 2020 is coming past. They're not going to have to divert any resources because that deadline is no longer operative. That argument is essentially mooted by subsequent events. In addition, I may also add that this is a cost-based argument. The BEP says we only have so much time to do everything. Well, then, they can add more people. They can add more staff. They can add more contractors. Yes, that costs money. But notwithstanding the explicit instruction of this court remanding for additional cost estimates, they didn't give any cost estimates as to how much it would cost to both add the RDF to 1 or 2 or 3 or 4 denominations, whatever, by 2026, and to include and to do the security redesign. And I may also add on that point that we begged the district court, we urged the district court, all right, Your Honor, we understand the government is claiming infeasibility. So then can't we just modify the injunctive order to require inclusion of the RTF at least by 2026, at least with respect to those specific denominations for which the government made no claim of infeasibility? And the district judge refused that order. And that seems to me very unreasonable. We could have obviated this entire litigation, not been here, had the district court just gone back to the government and said, well, what exactly denominations are you claiming are infeasible by 2026? And had they done that, and had they given us something, then we wouldn't even be here today. But
I thought their position was that all denominations.
Their positions, I'm sorry, Your Honor?
That to decouple the security from the accessibility would affect all denominations.
Well, Your Honor, it does affect all denominations, but the government made a claim of infeasibility here.
That's what I mean. That I thought their position was it is infeasible with respect to all denominations to decouple the security from the accessibility.
No, Your Honor, I don't believe that. Well, that's what the district court concluded, but that's not what the government argued. What the government argued is that it is infeasible to produce all denominations with the RTF by 2026. They didn't say, though, which denominations. In other words, they said we can't do it with all denominations, but they left open the clear implication that they could do it with at least one,
less than all,
more than one denomination.
That all means we can't do all implies we could do less than that.
Exactly.
Okay.
And that's the intent. That's the way we read it. And the government more or less conceded in their brief before this court that they could add the RTF to more than one denomination by 2026.
All right. If there are no more questions, then gentlemen, your case is submitted.
Thank you, Your Honor.
I have one more question, Judge Henderson. I'd like to ask the government again. What is your response to the last point? Have you said all or nothing? The district court said all or nothing. What about his argument that you should be required to deal with those denominations that you can do?
The response, Your Honor, is decoupling the security and accessibility redesigns for any denominations, and this is what the district court said, would delay the security redesigns. That's why that's our primary rationale, and it has really nothing to do with feasibility. Even if it's feasible that we do more than the $10 note, that we put the tactile feature on notes other than the $10 bill by 2026, doing that would require us to delay the security redesigns. It would expose everybody to an increased risk of counterfeiting. That's the basis on which we urge the affirmance of the district court ruling. And again, it just has nothing to do
Well,
with.
wait a minute. I thought you said you expected you would be able to do all of them by 2026.
No, Your Honor. Well, we expect
just a $10 bill.
correct, and we expect that we'll be able to put the tactile feature on all of the other denominations on the current schedule for the security redesigns of those denominations, which runs out. It's in the briefs, one in 2028, one in 2030, and so forth. So we expect that it will be feasible to put the tactile feature on all of the denominations by those dates. But what plaintiffs have fundamentally asked is that we be required to prioritize the accessibility redesign over the security redesign. And that would delay the security redesigns. And the primary basis of the district court's ruling was that it wasn't equitable to impose that delay. And that's the basis on which we urge affirmance.
Thank you.
I just do have one more question. On the updated timeline, Mr. Winnick, as of 2017, the outside date is for the $50 bill, 2032 to 2035.
I think, Your Honor, that it's not the 50. I think the 50 by the current schedule is actually the next one to be redesigned after the 10. It's then the 20 by 2030, the 5 between 2032 and 35, and the 100 between 2034 and 2038, which is, I think, a fairly standard staggered schedule owing to the need to address the distinct security features of each node.
Okay, I think it changed then from 2017.
It did change a little bit, Your Honor.
All right, thank you. Any more questions?
Your Honor, can I just respond briefly?
Go ahead.
Thank you, Your Honor. I would urge the court to take a very, very close look at paragraph 10, Mr. Olahar's declaration dated February 8, 2019 at page 739 of the record. The entire sum and substance of the delay claim is based on that single paragraph. And what does Mr. Olahar say? He says that any effort to pursue affixing an RTF to the legacy $10 note would divert resources and therefore cause a delay. We're not asking anymore that they even include the RTF on the legacy $10 note. That deadline has come and passed. That deadline was set for 2020. It's not going to happen. We're not even asking. This entire sum and substance of the delay claim is based on that paragraph, which is truly mooted and non-operative.
All right, well, we need to call an end to these proceedings or we'll go back and forth forever. All right, gentlemen, thank you. Your case is submitted.
Thank you, Your Honor.
This honorable court is now adjourned until Monday, September 21st at 9:30 a.m.